We have seen how the interpretation of Section 92 changed over time, and we already know that the free trade theory adopted by the High Court of Australia has a particular threshold to be met. The absolute freedom of trade and commerce will be breached if the state law imposes a discriminatory burden of a protectionist kind. Today, we are looking at two other decisions by the High Court of Australia about Section 92. Both decided unanimously with respect to the meaning of and the exceptions to the infringement of Section 92 by the imposition of a discriminatory burden of a protectionist kind. Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will look at the two Betfair cases. The first, Betfair in Western Australia from 2008, and the second, Betfair in New South Wales from 2012. Let's begin by looking at the first case. The issue in Betfair in Western Australia was that Betfair held a license under Tasmanian law to operate a telephone and internet betting exchange. Betting exchanges matches up bets on whether a particular competitor or team might win or lose. And then they offer better odds with better returns than state-regulated bookmakers or TABs, TABs, totalizator agency boards. Because of their lower commissions, less regulation, no state betting taxes, etc. So betting exchanges are cheaper to operate. Now, Western Australia legislated to amend the Betting Control Act of 1954, making it an offence to bet using a betting exchange. This obviously prevented Betfair from operating in Western Australia. The law also placed restrictions on access to information about race fields in WA. One needed approval to publish or otherwise make available a WA race field in the course of business. And, well, guess what? Betfair was not given access to these kinds of information. In sum, the law blocked the participation of Betfair to operate in Western Australia. So Betfair challenged the validity of the state law before the High Court, saying that the amendments breached Section 92 of the Constitution. The High Court, in a unanimous judgment, agreed. For the justices, the effect of the legislation of Western Australia is to restrict what otherwise is the operation of competition in the stated national market by means dependent upon the geographical reach of its legislative power within and beyond the state borders. This engages Section 92 of the Constitution. The law prohibiting betting exchanges being established did not discriminate against other states or interstate trade on its face, but it did protect WA operators in its practical effect. Do you see that? Well, as you know, the protectionist effect of law's burdens breaches Section 92 in the same way as an expressed burden of a protectionist kind. And you know it because you are subscribed to Aussie Law and our previous video was about it. So, in terms of the prohibition of publication of WA race fields and betting through internet betting exchanges, the law burdens Betfair's interstate trade and commerce and operates to the competitive disadvantage of Betfair and the advantage of WA operators. The issue here was one of cross-elasticity or substitutability. Let me explain. Cross-elasticity of demand is the effect on demand for one product when the price of another product changes. It happens when consumers are led to substitute one product for another similar product because the first has had its costs increase or became scarce or too burdensome to access. Hence the terms substitutability. The situation identified by the High Court in this case was that insofar as online betting exchanges are allowed, the demand for TAB services was anticipated to fall. So, by forbidding the practice of betting exchanges online, WA was increasing the substitution of this service for one that would continue to operate, the local, state-regulated TABs. In sum, the Western Australian law placed an indirect burden on interstate trade, which was protectionist in effect. But hey, remember Castleman II's? If the law has an incidental protectionist effect, but proportionally seeks to achieve another legitimate end, then that's okay. It does not breach Section 92. The Justice of the High Court, however, held that the Western Australian law was not reasonably appropriate and adapted. That is, it was not proportionate to achieve the objective of remedying loss of state revenue or even preventing corruption by securing the integrity of the industry in the state. Since the law was protectionist in effect and did not pursue a legitimate objective in a proportional manner, the law infringed Section 92 of the Australian Constitution. But then a new situation arose a few years later when the state of New South Wales charged some fees to access horse racing information in the state. The New South Wales law charged for access to racefields information upon the payment of a fee calculated by reference to what is called the wagering turnover, the turnover of bets of the company. Of course, since online betting exchange business's model involved higher levels of turnover, that meant that Betfair was required to pay higher fees than the other bookmakers. So Betfair argued that the fee imposed by the state of New South Wales was a discriminatory burden of a protectionist kind. The question before the High Court of Australia then was, is this New South Wales law breaching Section 92 of the Constitution by imposing a discriminatory burden of a protectionist kind? The justices of the High Court said no. As it seemed, Betfair's argument proceeded on the basis of an individual rights conception of Section 92 because it focused on the law's effect on Betfair only. However, Section 92 prohibits burdens on interstate trade, not disproportionate burdens on a particular trader. Chief Justice French, with Justice Gummel, Hayne, Crennan and Bell, said, "Not every measure which has an adverse effect between competitors will attract the operation of Section 92. Betfair must establish that the fee conditions imposed upon it were unauthorized because their practical effect is to discriminate against interstate trade and thereby protect the intrastate trade of the same kind. It is the concept of protectionism which supplies the criterion by which discriminatory laws may be classified as rendering less than absolutely free trade and commerce among the states." Betfair did not demonstrate a protectionist measure. Despite its suffering from financial loss because of the law, it did not show how the law prevented it from having or maintaining their market share and profit, or if it impeded them to increase such market share or profit in the state. As Justice Hayden said, a law cannot be characterized as protectionist merely because its practical operation imposes a burden on a single interstate trader. There was no protectionist discrimination on the law's face and no protectionist discrimination on its practical effect. The differential effect on Betfair was the product of its own distinctive pricing structures, business model and low profit margins. There was no evidence that the law would put Betfair at competitive disadvantage by reducing its market share or posing an obstacle to increasing its participation on the interstate market. Thus, we can learn two things from these two cases. One, if a burden, even if not discriminatory, imposed by a state law has an economic protectionist effect, that burden may breach Section 92. Two, not all economic impact suffered by interstate traders will amount to a violation of Section 92 of the Australian Constitution. I hope you enjoyed learning more about these two cases and about Section 92 of the Commonwealth Constitution. Make sure to like this video and subscribe to our channel before you go, and then I will see you again. Until then, ciao.